Hello, I'm Ritika Ganju, partner at Phoenix Legal with the practice focused in corporate and regulatory, specifically the pharma and healthcare sector. An important part of this industry is cosmetic, which have been regulated thus far alongside drugs under the provisions of Drugs and Cosmetic Act. With a huge range of international brands and booming domestic cosmetic production, it became inevitable for the regulator to streamline the regulatory processes and procedures for cosmetic. And hence what we saw was implementation of Cosmetic Rules 2020, which were issued under the provisions of Drugs and Cosmetic Act. These were, of course, the first step in streamlining the process dedicated to cosmetics. Here are the answers to some of the questions that you may have on these new rules. All regulatory license and approvals granted with respect to cosmetics thus far were sought and granted under the Drugs and Cosmetic Rules, with only a broad line distinction between drugs and cosmetics. But the new rules provide an exclusive procedure along with prescribed filing dedicated to cosmetics. Keeping the process, procedure, and filing for cosmetics separate from that of drugs is expected to bring efficiencies in administrative procedures and lead the foundation for much of sophistication and specialization that we are bound to expect in this sector. The new cosmetic rules became effective last year on 15 December 2020. The approval and licenses approved under the Drugs and Cosmetic Act will be valid till their respective expiry date or for a period of 18 months from the date of notification of the new cosmetic rules, whichever is later. The new cosmetic rules, of course, bring about new concepts and reforms to look out for. To start with, just as in the case of clinical trial regulations, we saw the concept of new drugs, which was introduced and is expected to evolve in next few years. Cosmetic rules also introduce the concept of new cosmetic. New cosmetic, which means that which contains a novel ingredient that has not been used anywhere in the world or is not recognized for use in cosmetics in any national or international literature. A prior permission from the Central Licensing Agency would be required before any application for manufacture import for new cosmetic can be made. Such prior permission of the Central Licensing Authority is expected to be subject to the data and information that applicant provides on the safety and effectiveness of such new cosmetic. Next would be the process and procedure for licensing, though it remains the same, but we see a new prohibition in case of imports, that is where the cosmetic expires in less than 6 months from the date of import. And certain raw materials have also been prohibited to maintain quality and standards of cosmetic. Good news is that the validity of the licenses for both import and manufacturing have been extended to perpetuity, which was not the case in case they were granted under the Drugs and Cosmetic Act, where they were 3 and 5 years respectively. And lastly, we see some innovative provisions that have been introduced to facilitate accountability checks. To say, for example, the government has decided to set up a first central cosmetic laboratory for carrying out analysis or test of cosmetics. Secondly, inspection, that was something which was a reserved power, has now been implemented in a way of mandatory requirement. Therefore, inspectors are required to mandatorily inspect a manufacturing licensed site once in every 3 years. And lastly, voluntary recall, which was not something that was provided under the Drugs and Cosmetic Act, has now been exclusively provided along with entire process and procedure under new cosmetic rules. So this was all from what we understand and what we know of cosmetic rules for now. Cosmetic industry is certainly expected to be working on these new requirements with much enthusiasm. And we look forward to corporates engage in the cosmetic sector to align their business operations with these new requirements. Thank you.